Excellent. Let's get started. So that the balance between effective regulation and allowing legitimate business activity is always a difficult one to strike at the margins. And therefore it's important to investigate how the changes in the Pension Schemes Act 2021 strike that balance. But more important still to us is to work out how those who run and who deal with businesses should react to the Act and what advice we should be giving them in respect of that. And that's the subject of this talk. The two speakers will be very well known to you and need no serious introduction, so I'll keep it brief so we can get into the talk. Gary Squires is a senior advisor at Lincoln Pensions, having been an MD at Alex Partners, and will be familiar to you through his work in the area in a number of the leading cases, including as an expert witness. Michael Tennet QC is a senior Silken Chambers with a deep love of regulatory matters. And before handing over to them, I'd encourage you to ask any questions at all using the chat function, and we'll come to them at the end. Thank you.
Thanks, Jonathan. Good morning, all. Historically, while the threat of the regulator's powers may have led to potential outcomes, they've tended to be used to their fullest extent post-insolvency. I've listed some leading examples on the slide, and the Section 89 regulatory intervention reports are available on the regulator's website if you're interested. So the powers have often been used against the backdrop of insolvency proceedings when debts are crystallised and any damage is clear, making it easier for the regulator to demonstrate that there's been loss with detriment to members and there's been time to investigate events. This would also be the time when other stakeholders are looking to maximise their recoveries, causing tensions between the pensions and insolvency regimes. Directors and office holders have responsibilities for the general body of creditors, and the pensions regulatory regime operates only to the benefit of the scheme creditor, or PPF. The cases I've mentioned were all pre-2021, and this tension is likely to be further increased by two matters. First is TPR's willingness to attack those running employers not only for trading at a loss for too long, damaging the outcomes for the scheme in the ultimate insolvency, but also for bringing about what the regulator terms an unnecessary insolvency, as in the Silent Night case. Potentially, this puts directors in a damned if you do and damned if you don't situation, and creates an obvious potential conflict with the insolvency regime, which requires directors to put a company into an insolvency process when it's necessary to protect the interests of all creditors, not just the pension scheme. This gives rise to what we have called the Goldilocks zone, where insolvency proceedings must be issued not too early or too late, but just at the right time. Secondly, the regulator has been granted new powers in the Pension Schemes Act 2021 that extend the scope of its CN powers against connected and associated parties and further allow it to seek civil and criminal sanctions against any person who causes harm to a pension scheme. As we'll see, the breadth of the new CN test will allow the regulator to investigate almost any significant transaction. At the same time, the regulator's new criminal powers are likely to have a chilling effect on the willingness of third parties to fund or transact with stressed scheme employers, which will in turn increase the likelihood that they'll end up in an insolvency process. In this presentation, I'm going to highlight some of the practical considerations for directors, stakeholders and advisors at each stage of the journey through distress and insolvency involving a DB scheme. And Mike's going to pick up on what we think are some of the more interesting legal considerations arising from those issues. Because of the novelty of the criminal sanctions and their overlap with the new CN powers, we'll focus on those rather than FSD considerations. We've sought to break down the presentation into three distinct time periods. Pre-insolvency, where the business is financially stressed and looking to effect a turnaround. The zone of insolvency, where the business is expected to become balance sheet or cash flow insolvent, and directors' duties have shifted to considering the interests of creditors. This is where restructuring discussions with the regulator and PPF are most likely to occur. And post-insolvency, where the regulator's powers of investigation and enforcement could clash with those of the insolvency officeholder. We've also given some thought to the question of settlement in the context of the regulator's new criminal policy. But before we go on to do that, Mike's going to summarise the key features of the regulator's new powers. So over to you, Mike.
Thank you, Gary. The Pensions Act 2021 has given the regulator 2 new powers to issue contribution notices and created 2 new criminal offences which it can prosecute. The new contribution notices have been added as Section 38C and 38E of the 2004 Act. And in broad summary, Section 38C applies to any act which would materially reduce the recoveries if a Section 75 debt had hypothetically fallen due immediately at the time of the act or immediately after the time of the act. And Section 38E applies if an act or failure materially reduces the value of the resources of the employer available to meet the same hypothetical Section 75 debt. So while on the face of it, these 2 contribution notices appear to overlap, it seems from the DWP's consultation paper that to avoid the overlap, Section 38C is going to be aimed at events that adversely affect the employer's balance sheet. And by using the term resources, Section 38E is intended to focus on events that affect the employer's future profitability. Now, that all seems very sensible until one realizes that many commercial transactions represent an exchange between capital and profitability. So many transactions will adversely affect one or the other. And I can give you some examples. Buying a business will adversely affect the capital of the company in the hope of boosting future profitability. Similarly, investing in a new IT system to help sales, or buying new stock in trade may reduce capital in the hope of improving sales and profit margins in future. Conversely, selling an associated business and its future profit stream or selling assets on a sale and leaseback will increase the company's capital but reduce future profitability. So the way the 2 new contribution notices have been drafted means that where the pension scheme is in deficit, simply entering into many ordinary commercial transactions is going to give the regulator jurisdiction to seek a contribution notice under one or other of 38C and 38E. In addition, the way in which the main statutory defences to these new contribution notices have been drafted is going to make them difficult to make out. I'm going to focus on Section 38C, but exactly the same issue arises under 38E. The key problem is the main so-called defence to the 38C contribution notice imposes a requirement that it was reasonable for the target to believe that the act complained of would not materially reduce the recoveries from the hypothetical Section 75 debt. But that Section 75 debt is hypothesised to fall due immediately after the act in question. Now, many, perhaps most transactions that involve the expenditure of capital, for example, the acquisition of your new computer system, will have the immediate effect of materially reducing the sums available for a Section 75 debt. And that is because the day after the transaction, it will not be possible to sell on the IT system or the stock in trade for the same amount as what had been paid for it. Now, in commercial terms, of course, that's not a problem because the commercial motivation for entering into the transaction will be to generate longer term profits and improve resources in the longer term. But that fact is not on the face of it relevant to the question of whether the statutory defence is made out. Now, it should be noted the same problem does not arise with the existing material detriment test under Section 38B. Section 38B allows the target to rely on the fact that it was reasonable to conclude that the act or failure would not detrimentally affect in a material way the likelihood of accrued scheme benefits being received. There's no temporal limitation in that test as to when the target has to assume the benefits will become payable. It allows the target to conclude that the transaction in question is in the long-term interests of all creditors, including the scheme and its members, even if it causes a temporary drop in resources. The mood music emanating from the regulator is that the new contribution notices are not intended to catch ordinary commercial transactions, which is welcome. And the regulator has emphasised the fact that it will only seek a contribution notice where it's come to the conclusion that it's reasonable to do so. However, against this, the regulator is only likely to be investigating that question of reasonableness when a transaction has already gone wrong. So there is an obvious risk that the regulator will take a less rosy view of the merits of the transaction than the directors did at the time they entered into it. The danger, therefore, is that the threat of these new contribution notices will make directors of companies less willing to try and trade out of financial difficulties by taking ordinary commercial risks, and this in itself will propel them further down the road towards an insolvency process, where, as we shall see in the talk, further problems will arise. Turning now to the new criminal offences, there are two new offences based on similar facts to the two new contribution notices. Under section 58A, acts are caught which are intended to prevent or reduce the recovery of a section 75 debt which would otherwise become due. Under section 58B, acts are caught which the target knew or ought to have known would materially affect the likelihood of scheme benefits being paid. These criminal offences are narrower than the new civil contribution notices. For example, the criminal offence in 58A only applies if there's an intention to affect the section 75 debt, and it only applies in relation to a section 75 debt which would otherwise become due. There is no hypothetical section 75 debt deemed to fall due immediately after the act in question. Further, in relation to both of the new contribution notes, criminal offences, there is a wider defence of reasonable excuse, which could theoretically include a belief that a transaction, even if risky in the short term, might be for the longer term benefit of the scheme and other creditors. However, the most material difference between the new contribution notices and the criminal offences for present purposes is that targets of the criminal offences do not have to be associates of the employer. They therefore include anyone who deals with the employer, such as suppliers, funders, advisors, and even trade unions. And that begs the question, to what extent in a pre-insolvency period, applying economic pressure or bowing to economic pressure to secure repayment of a lawfully due debt or seeking any other financial advantage from an employer might potentially be criminalised, because such action will generally tend to damage the pension scheme as a competing creditor. Again, the regulator has tried to reassure directors and creditors by offering guidance as to what they will and will not consider criminal conduct. And just to take two examples, the regulator has suggested that if a creditor of the employer seeks to improve its position by agreeing to roll over lending only on the basis of new security being offered, that conduct will not be considered criminal if the lending by the creditor is the only viable alternative to what the regulator terms inevitable insolvency. In contrast, the regulator has suggested that if a supplier uses its position as a creditor to take ownership of a business shorn of the management and pension scheme, this may well be considered criminal conduct if it results in the scheme being made insolvent, the company being made insolvent at a point where the regulator would not regard insolvency as otherwise inevitable. Now, the guidance, while welcome, still leaves many difficult issues for directors, suppliers and funders to wrestle with. As regards funders, it may be difficult to assess whether their offer of continued lending is the only alternative to an inevitable insolvency, so as to justify them seeking security. The directors, for example, may have a commercial interest in not sharing alternative offers of finance in order to maintain a negotiating position. As regards suppliers, there may be very good reasons why the supplier will be unwilling to offer further support to an employer without restructuring or a change of management. Otherwise, it simply risks throwing good money after bad. Yet an attempt to safeguard unsecured lending by taking over the business or trading on with security is now potentially criminalised if the regulator is not satisfied that insolvency is otherwise inevitable. Finally, when considering whether the actions of directors are to be regarded as criminal, the regulator's concepts of inevitable insolvency and unnecessary insolvency do not necessarily fit very well with the director's separate duties as a matter of insolvency law, as we shall go on to see.
Thanks, Mike. So with Mike's comments in mind about TPR's extended powers, what issues are stakeholders likely to face in stressed situation? The first set of considerations are for those running or dealing with employers that are in financial stress but not yet distressed. These are employers where financial distress and insolvency are becoming increasingly likely, but could possibly be averted with new investment and effective turnaround plan, allowing them to continue trading. Despite such situations occurring well before directors are likely to consider putting the employer into an insolvency process, there remain significant risks to directors who will need to be very mindful of the threat of CNs and even criminal prosecutions. Turnarounds need funding from investment, from asset sales, and from new lending. This is needed to fund losses, pay professional advisors, and meet other restructuring costs. However, turnarounds are not without risks, and any new investor or funder will be keen to protect their investment in the event of failure and make an appropriate return in the event of success. Where there's a material pension scheme, balancing stakeholder interests will become more challenging for directors, because most funders will require priority over the pension scheme for any returns in the event of business failure. If a turnaround is unsuccessful, the pension scheme is likely to receive a reduced return in the event of insolvency. So a failed restructuring could be detrimental to members' pensions and or the PPF. Even a partially successful restructuring, one that saves the company but subordinates the pension scheme behind significant debt, could be considered detrimental on balance or trigger one of the other CN tests. This presents certain risks that are likely to make stakeholders more cautious. Directors are ultimately responsible for the actions of the company and could find themselves a target of proceedings from the insolvency office holder and or the regulator if they can't justify that the actions they took were reasonable. Even if the business survives, any measures that subordinate the pension scheme and reduces its potential recovery in the event of subsequent insolvency could result in CN proceedings. Owners with significant influence or control are likely to be a key target for regulatory action, particularly if they've historically benefited financially from ownership, for example, through dividends. And lenders are less likely to be targets as a result of arm's length lending on commercial terms, even if it could be said to prejudice the scheme. But lenders would seem to be more likely to become targets if they connected parties with influence, for example, through internal group lending, or if they are considered to have acted deliberately to prejudice the pension scheme to profit financially, for example, by creating a burning platform as part of a loan-to-own strategy. While insolvency office holders have some protection, advisors could potentially become targets of criminal proceedings if they recommend an approach contrary to the interests of the pension scheme, possibly even if it's in the interests of the general body of creditors. So in stressed and distressed situations, as well as being mindful of their responsibilities to the pension scheme, when making decisions, directors should also consider their duties to the company and the point at which they also need to take into account the interests of all creditors as the employer approaches the zone of insolvency. This increased complexity and risk may stifle more creative solutions, potentially leading to suboptimal outcomes. So Mike's now going to talk about directors' duties as a matter of insolvency law.
Thank you, Gary. Well, quite apart from the risks of action by the pensions regulator in the pre-insolvency period, directors also have to be mindful of the fact that trading while insolvent can expose them to personal liability in respect of wrongful trading under the Insolvency Act 2002, under the Insolvency Act Section 214, misfeasance claims under 212, and of course directors' disqualification. Trading while insolvent can also lead to the company entering into avoidable transactions, transactions at an undervalue, preferences, and setting aside floating charges. There are also common law duties to have regard to creditors' interests, which can be triggered when a company's circumstances fall short of actual insolvency. So in the recent case of BTI and Sakana, which is now on appeal to the Supreme Court, the Court of Appeal decided that directors' duties to protect the interests of creditors generally arise at the point at which it is likely, on a balance of probability basis, that the company will become insolvent. The assessment of whether the company has become insolvent in all these cases will be under Section 123 of the Insolvency Act 1986. That involves a consideration of what is known as both cash flow and balance sheet insolvency. Neither the cash flow nor the balance sheet test is a simple snapshot test, especially when long-term liabilities like pension scheme liabilities have to be taken into account. As the case of Casa Estates in liquidation made clear, an ability to keep paying debts as they fall due, even for some time in the future, does not necessarily mean that a company is solvent, which is why the balance sheet test is also needed. And that's important because some small employers with larger pension schemes may be operationally profitable and thus cash flow solvent, but have little or no chance of paying off the pension deficit in the longer term, and so are arguably balance sheet insolvent. So CASA Estates requires the directors of those sorts of companies to ask how debts are being paid as they fell due, not only whether they can be paid as they fall due, and whether the effect of paying the debts is simply to send the company deeper into balance sheet insolvency. Conversely, in BNY Corporate Trustee Services and Eurosale, the court made the point that pure balance sheet insolvency at a point in time may not of itself demonstrate that a company is insolvent if it can pay its liabilities as they fall due, and if the future liabilities on the pension scheme on the balance sheet are very long-term in nature and may fluctuate in value before falling due. I mean, that is a perfect description of the pension scheme liability. It should also be noted that the Court of Appeal in Sakana expressly rejected the proposition that directors could only be criticised for not safeguarding creditors only if the company had passed the so-called point of no return, where insolvency was inevitable. They preferred a test that simply asked if insolvency was likely. That approach does not seem to fit very well with the regulator's deployment of the concept of inevitable insolvency when assessing the lawfulness of actions that injure the pension scheme, and also affecting the question of whether the regulator is willing to engage in restructuring arrangements affecting pension scheme liabilities. There also seems to us to be a danger that the focus on inevitable insolvency when trying legitimately to protect the pension scheme will place too much emphasis on cash flow insolvency. So not declaring insolvency until the employer physically runs out of cash may suit the pension scheme because it gives it the best chance of retaining the support of the employer covenant. But waiting for actual cash flow insolvency to supervene may not be in the interests of creditors generally. Gary.
Mike. So what are the conditions for regulatory and PPF engagement? Company directors may feel that they've reached the point where the company is likely to end up in an insolvency process, because while it may have the cash flow to keep trading, it's getting increasingly balance sheet insolvent because of mounting losses, or it can't afford meaningful DRCs. Yet they may be unable to engage with the regulator and the PPF. This is because, for the purposes of restructuring negotiations, as Mike said, the regulator in the case of RAAs and the PPF in the case of RAAs and CVAs would only engage if the company would otherwise inevitably experience an insolvency event, which is likely to occur within the next year per published guidance. That is effectively cash flow insolvent. Even if the regulator decides to engage, there's also a range of other non-statutory conditions that the regulator and PPF require to agree a consensual restructuring that may be unacceptable to other stakeholders. For example, an equity stake of 10 or 33%, depending on the circumstances. That's an equity stake in the restructured company. While these policies are the regulators and PPF's prerogatives based on their statutory objectives, this can put directors in a difficult position, as they may be presiding over a company that's on the balance of probabilities insolvent, yet is either not inevitably insolvent within 1 year or cannot otherwise meet terms required by the regulator, and is therefore unable to restructure consensually. When insolvency is likely, but regulatory engagement is not available, directors are therefore left with a dilemma and have a range of options. They can continue trading and attempt to restructure the business sufficiently to avoid cash flow insolvency. They can proceed with consensual restructuring in the face of resistance from the pension stakeholders, knowing it's likely to fail. That is, unless the PPF can be outvoted by other creditors. Or they can initiate non-consensual insolvency proceedings, such as administration or liquidation. These options require careful consideration, including the need to get the timing just right by finding the Goldilocks zone, which I'll look at next. Successful restructuring requires a credible funded turnaround plan. By that, I mean a plan clearly demonstrating the steps that will be taken to return a business to profitability, the availability of finance to meet the costs of those steps, and the impact they're expected to have on the business. In order to gain support from other stakeholders, the plan should also be compared with other options, such as a sale of the business or a liquidation. Where there's a DB scheme, considerations include the viability of the scheme. It's often possible to maintain cash flow solvency over extended periods by negotiating down DRCs. However, the viability of the scheme itself needs to be assessed under such conditions. This can be achieved, for example, via asset liability modelling. If on the balance of probabilities, the recovery plan is unviable, then logically, so is the employer. And expectations of success must be rational. Without a realistic plan and stakeholder buy-in, if directors proceed regardless and the company fails anyway, they risk exposing themselves to wrongful trading claims or claims for misfeasance. This can happen if creditor recoveries are reduced by losses, eroding cash sourced from secured borrowing or from distressed asset disposal. As highlighted by Mike earlier, the regulator has also been granted new powers to seek civil or criminal sanctions against individuals, including directors, who've caused harm to pension schemes. These will have to be borne in mind if the directors decide to trade on, as ordinary commercial transactions could result in the exercise of the new powers, especially if they don't work out as planned. It's almost inevitable that efforts to restructure the business will have the potential to cause harm to the pension scheme recoveries. For example, as we've seen, if secured funding is provided in support of a turnaround plan that subsequently fails, or if the scheme is compromised in a pre-pack administration. As a consequence, the reasonable excuse defence to the criminal sanctions becomes critical. While a common theme of responses to the regulator's consultation was a request for greater clarity, the regulator does highlight key factors in determining a reasonable excuse, including as follows: whether the detriment to the scheme is incidental rather than a fundamentally necessary step, for example, a decision to withdraw credit, whether adequate mitigation has been provided to the scheme, and whether there were viable alternatives that could have been pursued that would have a less damaging effect on the scheme. The regulator also sets out some examples of behaviour where it would expect to investigate on a criminal basis, which include mismanagement of the business, value extraction and asset stripping, and the new transgression of unnecessary insolvency. All of these could also constitute misfeasance. Should a turnaround not be considered feasible without a compromise of liabilities, informal options such as debt for equity swaps or formal consensual processes such as CVAs or schemes of arrangement may be possible without regulatory approval or PPF approval, either when the PPF can be outvoted by the creditors or the scheme is not to be compromised. However, creditors often object to being subordinated behind the pension scheme. So running the scheme through a restructuring that compromises financial or other creditors, but not the scheme, is rarely an option. Initiating non-consensual insolvency proceedings is also not without its risks. As Mike's already noted, the regulators coined the phrase unnecessary insolvency in both the Silent Night CN case and in its draft guidance on criminal proceedings, which, unlike CN and misfeasance claims, can extend to non-associated parties. This refers to cases where it's alleged that the company could have continued to trade and pay contributions to the pension scheme, and the purpose of crystallising an insolvency event was to abandon the scheme. This could also expose directors, including shadow directors, to claims for misfeasance. Mike's now going to talk about the risks of initiating non-consensual insolvency proceedings.
Thanks, Gary. So if the regulator is not persuaded that insolvency is inevitable, but the directors believe that insolvency under Section 123 is likely, they would seem to be caught between a rock and a hard place. It seems to us the safest course for directors may still be for them to go into a non-consensual insolvency process if there is a genuine concern about wrongful trading. The regulator is likely to find it hard to argue that either the directors or non-scheme creditors could be liable for a contribution notice or commit a criminal offence simply by initiating or voting for a court-approved insolvency process, even if the effect of that process is to reduce the obligations to the scheme. And in any event, as the regulator acknowledged in its Section 89 report on Silent Night, it would not ordinarily expect lenders to bring about unnecessary insolvencies, and so the regulator would not usually anticipate targeting them for doing so. None of this, however, would stop the regulator arguing, as it did in Silent Night, that events that occurred pre-insolvency created the conditions for what they regard as an unnecessary insolvency, and attacking directors and creditors not for the initiation of the insolvency process itself, but for creating the conditions where the insolvency process became necessary. In this situation, initiating the non-consensual insolvency process will have the additional downside of crystallizing, but not limiting the losses which the regulator might claim against the directors. In other words, or shadow directors. In other words, it could create a situation, as in the Silent Night case, where the regulator continues to argue that but for the insolvency process, the employer would have been able to trade on and meet the scheme deficit in full in due course. Given the competing pressures and duties on directors and funders in the pre-insolvency period, it seems both to Gary and I that the most instructive case on how to deal with those pressures continues to be Johnson Press, even though it predated the Pensions Act 2021 and the regulator's latest guidance. In Johnson Press, the bondholders did manage to acquire the business shorn of the pension scheme, and without reaching a prior agreement with the regulator or the PPF. And what they did well in that case, the bondholders, was to avoid interfering directly in the management of the employer in the pre-insolvency period so that they did not become shadow directors. They did nothing to accelerate the point at which the debt they were owed had to be repaid. They allowed the directors a reasonable shot at selling the business to other persons, which process helped demonstrate there was likely to be nothing for unsecured creditors like the pension scheme in the event of a sale. And the bondholders only stepped in with their own offer for the business based on offers already made after a court had ordered the appointment of an administrator on the basis that the employer was insolvent. And another interesting feature about Johnson Press is that, as I understand from Gary, who was involved in the case, the court ordered the appointment on the basis that the company was balance sheet insolvent, not cash flow insolvent. Yet the regulator seemed happy the involvement of the court demonstrated that the insolvency was still inevitable. In contrast, if insolvency does not result from a court-approved process, for example, an appointment of an administrator under qualifying floating charge, as in Silent Night, the regulator may be less willing to accept that the insolvency was indeed inevitable.
So attempts to turn the company around failed, and we're now into an insolvency process. Officeholder obligations regarding investigations and pursuit of insolvency claims are set out in Statement of Insolvency Practice 2, headed Investigations by Officeholders in Administrations and Insolvent Liquidations, and the submission of conduct reports on by officeholders, which is issued by the insolvency regulatory bodies. As already explained by Mike, insolvency practitioners have a range of potential tools at their disposal to make recoveries for the insolvent estate's creditors generally, including avoidance of antecedent transactions, wrongful trading, and misfeasance. Misfeasance is also likely to catch the attention of the regulator. Section 212 of the Act applies to company office holders, including shadow directors, who have misapplied or retained or become accountable for any money or other property of the company, or been guilty of any misfeasance or breach of any fiduciary duty or other duty in relation to the company. Mike would explain that given its new civil CN powers, the regulator would also have the ability post-insolvency to seek contributions from directors and associates in respect to a very wide range of pre-insolvency transactions that, with the benefit of hindsight, may not have worked to the advantage of the scheme. However, quite apart from that, the regulator also has the ability to bring criminal proceedings in respect of similar transactions. In its recent draft policy document, Our Approach to the Investigation and Prosecution of the New Criminal Offences, the regulator provides 4 examples of circumstances that might give rise to prosecution, of which 3 might also include misfeasance. These are the purchase of an employer with no further investment into its business, subsequent mismanagement of the company, and the extraction of value before the company went into administration, the stripping of assets from an employer, which resulted in substantial weakening of the support for the scheme, and taking steps to bring about the unnecessary insolvency of the scheme employer with the intention of buying the employer's business without the scheme. These examples should also be of interest to insolvency office holders and could give rise to competing claims. This is important because recoveries by insolvency office holders benefit the company's estate and its general body of creditors, whereas successful claims by the regulator benefit only the scheme. I'm not aware of any published precedents yet for resolving such conflicts, but Mike's going to talk about some of the issues that arise.
Thanks, Gary. So I think there are a couple of areas of overlap of claims in a post-insolvency period which are worth mentioning. The first area is the area already identified by Gary, which is the overlap between contribution notices and misfeasance claims against directors and shadow directors under Section 212 of the Insolvency Act. As Gary has pointed out, many acts which amount to misfeasance will also fall foul of the contribution notice regime, particularly given its expansion. Yet the two regimes benefit different creditors. And there's no clue in either piece of legislation and no guidance as to how the two regimes interact and how the regulator and the insolvency office holder should coordinate their efforts. Further, which of the regulator and the insolvency office holder brings proceedings first is capable of making a significant difference to creditors. There's the possibility that the first claim, be it misfeasance or contribution notice, will bankrupt the director or shadow director or exhaust their insurance cover, and that'll leave nothing left for the second claim, and that will leave either the scheme or the general creditors of the employer out of pocket. Looking at the same problem from the point of view of the director or shadow director, they are potentially subject to double jeopardy in respect of the same act of misfeasance. Again, there's nothing expressed in the legislation that prevents double recovery against the director or shadow director in that situation. Instead, they will be left to argue from first principles that the nature of the contribution notice and the misfeasance regimes is such that double recovery shouldn't be allowed. For example, if the director has already compensated the general body of creditors for an act of misfeasance, the director would have to argue that it would not be reasonable for the regulator then to seek a contribution notice in respect of the same acts, or at the very least that the contribution notice should deduct sums which have already found their way to the scheme as a result of the misfeasance claim. Similarly, if a director has already compensated the scheme under a contribution notice, they would have to seek to argue that the scheme should not be further compensated via a misfeasance claim on the basis that it is at its root a compensatory regime. This potential for double recovery also needs to be borne in mind by directors seeking to settle contribution notice and misfeasance claims, and we'll be looking at that in a moment. The second potential area of overlap in an insolvency situation that deserves mention is the overlap between a contribution notice in favour of the scheme and the Section 75 debt owed by the insolvent company to the scheme. The key provision here is Section 50 of the Pensions Act 2004, which governs the relationship between the contribution notice and the Section 75 debt. The general policy intent behind Section 50 seems to be that if the regulator has decided in its wisdom to issue a contribution notice against a person, prima facie that person is a more appropriate funder of the pension scheme than the employer via its Section 75 debt. Thus, Section 50 subsection 6 provides that any sums paid to the scheme or the PPF pursuant to the contribution notice are to be treated as reducing the amount of the debt due from the company or liquidator under Section 75 of the 95 Act. So it follows that in some situations, the regulator seeking a contribution notice may actually operate indirectly for the benefit of the wider body of creditors, because lowering the Section 75 debt against the employer will increase the assets available for the employer's other creditors. It should also be noted that under Section 50, subsection 4, the regulator has a discretion to direct the trustees not to pursue a Section 75 debt against the employer pending recovery of a contribution notice. Now, in contrast, if sums have already been paid by the employer under a Section 75 debt, the target may apply to the regulator for reduction in the contribution notice, but any such reduction is stated to be a matter of discretion for the regulator. There appears to be no provision in Section 50 or other legal principle to suggest that paying a contribution notice would give the target any right of subrogation or indemnity against the employer for having reduced its Section 75 debt. As a final point, it's not clear how Section 50 will work in relation to a settlement. On the face of it, a voluntary settlement of proceedings for a contribution notice will not fall within Section 56. So that issue needs to be addressed if a target, which is also a creditor of the employer, is considering settling contribution notice proceedings.
Thanks, Mike. So the scope for confusion is considerable, and it's not just the overlap between insolvency and pensions jurisdictions. There's also the question of quantum and settling any proceedings. As the regulator makes clear in its draft guidance, there's no clearance available for criminal acts, and settling a civil case may not provide absolution from a criminal case, making settlement more unlikely. We consider this latter issue next. Per the consultation document, successful criminal prosecutions under the Pensions Act require an act or failure to act that's harmful to the scheme, intent or knowledge of consequences, and no reasonable excuse. One of the questions that was raised prior to the draft policy on the investigation and prosecution of criminal offences is whether clearance would be available for criminal sanctions, much like it is for the equivalent CN test. This has to some extent now been addressed by the regulator in its draft policy, which says, our practice when granting clearance is to issue a statement to the effect that in our opinion, in the circumstances described in the application, it would not be reasonable to impose liability on the applicant under a CN. Section 42 does not apply to offences under sections 58A and 58B, and there's no equivalent provision applicable to those offences. So it seems pretty clear that clearance for criminal proceedings is not available. And a further question arising is the extent to which settlement of a civil claim or CN case would be factored into a potential criminal prosecution. This is partly addressed in the regulator's March 25th, 2021 settlement policy, where it states, where we're considering using or are pursuing use of more than one power, we may choose to reach a settlement in respect of some, but not all of these powers. In this instance, the steps set out in consequences of settlement above will apply only to the powers subject to the agreed settlement. The enforcement action in relation to the other powers will continue. The implication of this is that a settlement of a civil claim or CN would not of itself result in the cessation of criminal proceedings. However, in practical terms, it's important in settlement negotiations that all potential avenues of claim are considered and, if possible, closed off. If not, a party considering settlement of CN or misfeasance claim should logically wish to ensure they're not going to end up in prison regardless. If such reassurance was not available, there would be limited incentive to settle, and they might prefer to take their chances with pursuing proceedings to the bitter end. Mike's going to address some of the legal consequences of this next.
Thanks, Gary. So just to recap, it follows from what we've already been saying that there are a number of points that need to be borne in mind when settling post-liquidation claims by the regulator or the liquidator. First, as we've seen, a contribution notice claim will not give the target immunity against misfeasance claims. So when you settle a contribution notice claim or a misfeasance claim, the target may want to consider whether an overall settlement of both liabilities is possible. Secondly, if the target, because of its relationship with the employer, is owed money by the employer, in all cases where it settles a contribution notice, it will want to ensure that that results in a reduction of the Section 75 debt. Otherwise, the target will effectively be losing out twice. And this could even necessitate the actual issuance of a contribution notice by agreement in a particular amount so that Section 50 is engaged. And finally, as Gary has just mentioned, because of the 2021 Act, settlement negotiations with the regulator are in future going to be complicated by the possibility of criminal sanctions. Now, on the one hand, since there is a public interest in settling civil contribution notices, one would not like the possibility of criminal proceedings to make civil contribution notices unsettlable. But no target, as Gary's pointed out, is going to be willing to settle civil proceedings while an unresolved threat of criminal proceedings is hanging over them, not least because settlement would look like an admission of guilt. That said, linking the settlement of a civil contribution notice claim and criminal proceedings is likely to turn the threat of criminal sanctions into a bargaining chip in settlement negotiations. And that leads to some very uncomfortable outcomes as a matter of public policy. For example, the regulator might be tempted to throw in the threat of criminal proceedings as a way of forcing more money from a target that was otherwise unwilling to settle a civil claim on its merits. And it's also a troubling notion that a person with deep pockets should be able to buy their way out of a criminal liability where Parliament has judged their actions to be deserving of a criminal sanction. The regulator's current guidance seems to give little comfort on either of those points. On the contrary, the regulator expressly contemplates that it might seek a criminal sanction where the target has no funds to meet a civil contribution notice. So the regulator does seem to be suggesting that poor people are more likely to be criminalised than rich ones. It seems to me that the only way out of these difficult policy issues is for the regulator to effectively take a decision on bringing or not bringing criminal proceedings before it seeks any civil contribution notice, so that the decision as to whether to launch criminal action is not influenced by the assets of the targets or their willingness to settle the civil claim. And then the civil claim could be settled without regard to the criminal proceedings, which will be effectively have been taken off the table. Gary.
Thanks, Mike. So the interplay of the insolvency and pensions regimes is becoming ever more complex, with some fine judgments to be made at each phase of sponsor decline into insolvency, from attempts to turn around a distressed company, through the timing of insolvency proceedings and the consequences of getting the judgments wrong. So what are the practical steps that can be taken to minimize risk? Restructuring situations can be fast moving and complex, and when decisions are reviewed with the benefit of hindsight, it'll be necessary to show that expectations of success were rational and that there was a reasonable excuse for any detriment to the pension scheme. So be prepared to justify any decision to continue trading by reference to credible plans and options analysis. It should be recognised that consensual restructuring is likely to need regulatory or PPF approval, which may not be forthcoming, or the attached conditions may be too expensive or risky for funders. If there's only a smouldering platform, attempts to create a burning platform to crystallise engagement are high risk. Non-consensual restructuring could be deemed unnecessary if it can't be demonstrated that all options were properly explored and the scheme had not suffered unfairly. And consider seeking clearance to establish a reasonable excuse. Clearance for a CN, which may have implications for reasonable excuse under the criminal sanctions. So in short, consider all options, document them and the resulting decisions, take advice at every step of the way, and understand the legal positions and duties throughout. Thank you. And I think we now have some time for questions. So back to Jonathan.
Yes, you have admirably finished almost to the second, 10 minutes before 12 o'clock. Credit to you both. We've got some questions. So on the theme of reasonable excuse, we have a question about clearance. While clearance doesn't directly address criminal liability, is it conceivable that a person could be criminally liable for engaging in conduct in respect to which clearance has been granted, assuming there's no material deficiency in the clearance application? I.e., is clearance bordering on incontrovertible evidence of reasonable excuse, or is it not so simple? What do you think on that?
Shall I take that, Gary?
Yeah,
I mean,
yeah, sure.
I think it's fair to say it must be bordering on incontrovertible evidence of reasonable excuse. I mean, the fact is that the civil contribution notices are wider, and they on the face of it, clearance for the wider offence ought to give you a reasonable excuse in relation to the criminal offences which are based on you having a malign intention or trying to put one over the pension scheme. So it would be almost inconceivable that there would be a situation in which the regulator was prepared to clear a transaction, and then be able to turn around and say, nevertheless, it fell foul of the criminal offences.
Excellent, thank you. Another one, do you think that non-statutory TPR/PPF restructuring requirements may be unreasonable from a public law perspective, given the tensions now created by the new sanctions? And equally, should the regulated apportionment arrangement regulations be amended to remove the 1 year requirement?
I'm
tempted to say over to Gary on that one, but
well, except the public law aspect, except from the public law aspect of it, I would say that it would make sense to me that the pensions regulatory and insolvency regimes should be aligned, because at the moment it creates some very difficult situations. It can create very difficult situations for directors, as Mike says, who are caught between a rock and a hard place.
Well, I don't hold myself out as an expert in public law, but I would question whether a negotiating position in relation to restructuring would be a judicially reviewable decision by the regulator. But that is simply my gut reaction. I don't know whether, Jonathan, you have any thoughts on that.
I'll leave that one to you, MT. Very kind. And then last question, any thoughts on whether the regulator's threat of criminal proceedings could be blackmail? A provocative question.
I use the word extract rather than extort in my script on that. I am uncomfortable about the idea, as you heard during the talk, about the regulator using the threat of criminal sanctions to get money out of people. I'm certainly not suggesting it would in fact use it in an improper way or blackmail people, but I think that it's unhelpful that it might even be perceived in that way.
I think that answers all the open questions. Actually, there's one more's coming. Oh, two more flooding in suddenly. Hang on, two more are coming in. Could the statutory defence for the material detriment test be a relevant factor towards whether a reasonable excuse exists?
Well, I think, under both insolvency and pensions regimes, that there is a requirement to act reasonably and to have reasonable expectations for the future. So if the statutory defence is established, as I've said, through proper analysis and documentation, then one would think that that would be relevant in assessing reasonable excuse.
Yeah, I mean, the fact that you have a reasonable excuse will come into at various other stages. It just doesn't directly engage the main statutory defence. So it will come into the question of whether the regulator considers it reasonable to issue proceedings. It may come into the question as to whether it was reasonable to offer mitigation for the pension scheme. I mean, if you have a long-term profit motive, it might be said, well, you would effectively working for the good of the pension scheme in a way that didn't require you to mitigate the short-term downside. So it's clearly that the sort of factors that feed into reasonable excuse don't become irrelevant. It's just that of themselves, they don't fit neatly within the main statutory defence to the new contribution rate notice offences.
Lovely. One more with your criminal law hat on, Mike. Would agreement by TPR not to prosecute preclude prosecution by the CPS?
Yeah, I hope they would coordinate. On the face of it, I don't think it just reading it, I don't think it would. But I mean, again, that may involve all sorts of issues of public policy relating to criminal law, which I am not expert enough to comment on.
Can I ask you one finally? Obviously, you've identified very helpful a lot of difficult areas. I remember similarly in 2008 at the time, the legislation was amended then. There was a lot of difficult areas identified then, only some of which really turned out to be significant practical problems. Of the ones you've identified, which do you think are going to be the most difficult in practice, if you could pick out one?
It's difficult to say, because I think, clearly a lot depends on the way the regulator itself goes about its business. I mean, they have these massively wide powers, but obviously a lot of the problem will be if they exercise them in a massively wide way. I mean, they have not suggested that they are trying to change the basis on which they've historically regulated, which I think is a good thing. But of course, that slightly begs the question: well, why have you got all the new powers? And you know, the way they're regulating at the moment does rely a lot on this concept of inevitable insolvency, which, as we've heard from Gary, and that does potentially at least conflict with the duties of the directors as a matter of insolvency law.
Understood. And you've really opened yourself up by your excellent timekeeping here. Another question's come in. Do you think it likely that TPR will prosecute for the criminal offence after having successfully pursued a CN claim?
Well, they, as I say, my suggestion is they did the criminal first, because if that's got out of the way, then the criminal, the civil claim can be settled without the threat of the criminal proceedings hanging over the target, and in a way that isn't influenced by the criminal proceedings. But there's nothing which tells the regulator the order in which they have to go. They're their own powers. So that's simply my suggestion for how it might properly be managed. But if there's no, assuming no settlement, yes, that the regulator could do it in either order.
And one more question on the prosecution theme. Can you see a risk of private prosecution in a highly publicised CN case?
Oh no, again, it's not something I'd looked at. I wasn't sure the legislation admitted the possibility of a private prosecution, but again, I haven't looked at it specifically with that point in mind.
It's an interesting question whether I suppose it originates from the different stakeholders who might have an interest in doing so were one to be available. Lovely. I think you have answered absolutely everything. Thank you very much. That was extremely stimulating indeed. So thank you very much everyone who's listened for attending today's webinar. We really value your feedback. A short questionnaire, but only a short one, will pop up in your browser once the session is over. And we'd very much appreciate your views on how you find the session, any topics you'd like to hear from us in the future. And I hope you'll comment on the excellent timekeeping of Gary and Mike. The recording of this webinar will be available to view on our YouTube channel later this week in case you missed any of the session. To find our channel, type Wilberforce Chambers in the YouTube search bar. As I mentioned at the start, today is the first of our 2021 Nugee pension lectures. There are 2 more to follow this month. The next is on Tuesday next week at 11, where we'll hear from Paul Newman QC on topical issues in public sector pensions. You should already have the details on how to join, but if not, please email seminars@wilberforce.co.uk. Thank you very much. I'll bring the session to an end now.
Thanks, everyone.
Thank you.